Colin O'Keefe here for LXPN TV. A California judge recently dismissed Apple's suit alleging that Amazon couldn't use the phrase App Store because it would cause confusion among consumers and violate Apple's intellectual property. Joining me to discuss the case is Sarah Tremont of Covington and Burling, an author on their blog Inside Tech Media. Sarah, first, can you explain the background and the results of the case? What exactly happened here?
Well, Colin, it began in 2011 when Amazon launched the App Store for Android mobile devices. Amazon shortly brought suit claiming that they owned the trademark to the term App Store and that they had sunk a lot of marketing costs into developing that as a particular term for the kinds of services they offered to users of the iPad, iPhone, and iPod mobile devices. Amazon brought a countersuit claiming that App Store is actually a generic term, meaning that it merely describes the category of goods and services to which it applies. The case went on until January of this year. The federal district judge in California actually dismissed one of the claims that Apple had brought against Amazon, saying that they had not falsely advertised by using the term App Store in promoting the App Store for Android. The case then went into settlement negotiations, and then just this past month eventually was resolved when Apple issued a covenant not to sue to Amazon, which essentially mooted that counterclaim and allowed Amazon and Apple to both continue using the marks.
I see. So second, what's next here? Can Apple still pursue this App Store trademark?
Well, Apple's actually, before bringing suit against Amazon, had filed an application to register the trademark App Store with the Patent and Trademark Office. That matter was actually opposed by Microsoft, who is attempting to block the application and not allow it to register. That is currently before the Trademark Trials and Appeal Board, which had stayed that proceeding while the litigation went forward. Now that the litigation is over, that proceeding is set to resume, and we'll just have to see what happened, though it certainly doesn't help Apple's case that Amazon is now allowed to keep using the mark.
Absolutely. It's going to be interesting to see what happens here, but as you mentioned, it seems very unlikely that Apple's going to be able to pull this out and obtain the exclusive rights to use the term App Store as a trademark. Once again, that was Sarah Tremont of Covington and Burling. For more of her insight on this case and other stories like it, be sure to visit InsideTechMedia.com. And of course, if you're not already watching us here on our site, visit LXPN.com for more of these LXPN TV, video interviews, and curated commentary from the LexBlog Network's more than 8,000 members. Thank you for joining me today, Sarah.
Thanks, Colin.